Thank you very much. It is my esteemed pleasure and honor to welcome Honorable Mr. Justice Sanjeev Khanna, Supreme Court of India and Executive Chairman, National Legal Services Authority, NALSA. Honorable Mr. Justice Sandeep Mehta, the Judge, Supreme Court of India. Honorable Mr. Justice Manindra Mohan Srivastav, the Chief Justice of Rajasthan and Patron-in-Chief of Rajasthan State Legal Services Authority. Honorable Mr. Justice Pankaj Bhandari, Judge, Rajasthan High Court and Executive Chairman of Rajasthan State Legal Services Authority. And Dr. Justice Pushpendra Singh Bhati, Judge, Rajasthan High Court and Chairman, Rajasthan High Court Legal Services Committee, Jaipur. The dignitaries that are amongst us, they personify intellect, integrity and wisdom. They illuminate the legal world and lighten the paths of Indian populace with their sense of righteousness and judgments. I extend a hearty welcome to this august gathering on behalf of Rajasthan High Court and Rajasthan State Legal Services Authority. We are here for a one-day colloquium which will have a deliberation on a topic that encompasses all in the society and especially those that are at the bottom of the pyramid. The Constitution of India provides the rights of equal opportunities for all. The Constitution of India also emphasizes that no person gets deprived of economic partake because of poverty, and no person is denied access to legal aid and justice because of disability, poverty, caste, gender, or age. However, the challenge that we face is the accessibility of legal aid to the people at the bottom of the pyramid. The bottom of the pyramid, whereas everything is scarce, whatever resources we have, the nature has given to us, everything is scarce. So challenge is to people providing legal aid at the bottom of the pyramid. Ladies and gentlemen, the topic of the day is exactly this, is the legal aid and social justice and challenges, opportunities in access to justice. Before we start the colloquium, as a token of respect and our admiration for our dignitaries and guests, we present plans embodying the essence of growth, vitality, sustenance, and life that echo with the temples of law and its luminaries. To present the plans as a token, I invite the following to gift the plans to dignitaries. First of all, I request Honorable Mr. Justice Dinesh Mehta, Judge, Rajasthan High Court, to please come and present a beautiful plant to Honorable Mr. Justice Sanjeev Khanna, Judge, Supreme Court of India and Executive Chairman, National Legal Services Authority, NALSA. Thank you, sir. Now I request Honorable Mr. Justice Indrajit Singh, Judge, Rajasthan High Court, to please come and present the token representing life to Honorable Mr. Justice Sandeep Mehta, Judge, Supreme Court of India. Thank you very much, sir. Now I request Honorable Mr. Justice Avnish Jhingam, Judge, Rajasthan High Court, to please come and present the plan to Honorable Mr. Justice Manindra Mohan Srivastav, the Chief Justice of Rajasthan High Court and Patron-in-Chief of Rajasthan State Legal Services Authority. Thank you, sir. I request Mr. Pramil Kumar Mahathur, Member Secretary, RSLSA, to please felicitate Honorable Mr. Justice Pankaj Bhandari, Judge, Rajasthan High Court and Executive Chairman, Rajasthan State Legal Services Authority. Thank you, sir. Lastly, I request Mr. Shipi Shrimali, Registrar General, Rajasthan High Court, to please come and welcome Honorable Dr. Justice Pushpendra Singh Bhati, Judge, Rajasthan High Court and Chairman, Rajasthan High Court Legal Services Committee, Jaipur. Thank you, sir. I thank once again all of you. This colloquium is convened in continuation of the Platinum Jubilee, celebration a remarkable stone in the history of Rajasthan High Court. Various events and activities are being organized under it. Pedantically choreographed events exemplify the Rajasthan High Court's 75 years of steadfast commitment to uphold justice and legal excellence in Rajasthan. Ladies and gentlemen, now let's play Nalsa song that symbolizes our endeavors to provide legal aid to the weakest section of the society.
एहसास न्याय का सबके लिए, आकाश न्याय का सबके लिए, उल्लास न्याय का सबके लिए, विश्वास न्याय का सबके लिए। हिंदुस्तान पर हक हमारा भी तो है, इंसाफ के इस आशिया पर हक हमारा भी तो है। एक मुट्ठी आसमां पर हक हमारा भी तो है, एक मुट्ठी आसमां पर हक हमारा भी तो है।
ये ना सोचो दर्द हमारा कहीं सुना न जाएगा, अब न्यायालय खुद चलकर चौपालों तक आएगा।
लाचारों को न्याय मिलेगा, दुखियारों को न्याय मिलेगा, कमजोरों को न्याय मिलेगा, मजलूमों को न्याय मिलेगा। अपने इस हिंदुस्तान पर हक हमारा भी तो है, उम्मीदों के इस गुलसितां पर हक हमारा भी तो है। एक मुट्ठी आसमां पर हक हमारा भी तो है, एक मुट्ठी आसमां पर हक हमारा भी तो है।
गरीब और कमजोरों को मुफ्त एवं सक्षम कानूनी सहायता के लिए प्रतिबद्ध विधिक सेवा प्राधिकरण नालसा, न्याय सबके लिए।
Thank you very much. This is indeed a pithy. It embodies, signifies the endeavor that NALSA and RALSA together do to provide legal justice and aid to the people who are standing in the last mile. Honorable Mr. Justice Pankaj Bhandari, Judge, Rajasthan High Court and Executive Chairman, RALSA, is a legal luminary. Lordship has enriched this institution by his erudite judgments and fine sense of wisdom. May I now request Lordship for the welcome address?
A very good morning to all. Honorable Mr. Justice Sanjeev Khanna, Judge Supreme Court of India and Executive Chairman, National Legal Service Authority. Honorable Mr. Justice Sandeep Mehta, Judge Supreme Court of India, Honorable Mr. Justice Manindra Mohan Srivastav, Chief Justice, Rajasthan High Court, and Patron-in-Chief, RSLSA, Brother Justice Dr. Pushpendra Singh Bhati, Judge, Rajasthan High Court and Chairman, Rajasthan High Court Legal Service Committee, Jaipur, esteemed colleagues, senior advocates, Chairman, Bar Council of Rajasthan and members of the Bar Council, Additional Advocate Generals, President and Office Bearers of Rajasthan High Court Bar Association both at Jodhpur and Jaipur, President and Office Bearers of Jaipur Bar Association, officers of the High Court Registry, officers of Rajasthan State Legal Service Authority, press and media persons, distinguished guests, ladies and gentlemen. With profound pleasure and esteemed honor, I extend a heartfelt welcome to all distinguished guests and participants gathered today for the colloquium on legal aid and social justice challenges and opportunities in access to justice in the beautiful pink city of Jaipur, Rajasthan, on Sthapna Divas of Rajasthan, today being Sthapna Divas of Rajasthan. Allow me to extend a special welcome to our chief guest, Honorable Mr. Justice Sanjeev Khanna, Judge, Supreme Court of India, Executive Chairman, National Legal Service Authority. Sir, your presence here today is a testament to your unwavering commitment to the cause of justice and your invaluable contributions to the legal fraternity. We are truly privileged to have you grace this occasion with your wisdom and insights. I would also like to extend a heartfelt welcome to our guest of honor, Honorable Mr. Justice Sandeep Mehta, Judge, Supreme Court of India. Your presence here today reflects your dedication to the pursuit of justice and your invaluable support for initiatives aimed at enhancing access to legal and aid services. We are deeply grateful to you, sir, for your presence and eagerly anticipate your valuable contributions to our deliberations. I also extend a warm welcome to our Patron-in-Chief, Honorable Mr. Justice Manindra Mohan Srivastav, Chief Justice of Rajasthan High Court. His unwavering commitment to justice, fairness and equality serves as a beacon of inspiration for us all. We are deeply honored to have him grace this occasion as our Patron-in-Chief, and his presence elevates the significance of our gathering today. A warm welcome to our esteemed guests of the dais, my colleagues. Your participation and engagement in today's proceedings are equally significant. Your perspectives and contributions enrich our collective understanding and propel us forward in our mission to promote social justice and access to legal aid. As you all know, by inclusion of Article 39A in the Constitution through the 42nd Amendment in 1976, it changed the legal landscape. It enshrined the right to free legal aid, emphasizing the state's obligation to ensure that opportunities for securing justice are not denied to any citizen due to socio-economic constraints. I would just like to quote something, in fact, not quote something, to share an experience which we had while sitting in the DB criminal roster. Just last year, 31st of March, a matter came up where the appeal of a convict was not filed for 6.5 years. So that was an eye-opener for us. We called the member secretary. The member secretary informed us that advocate has been engaged. We called the advocate. He said, I did not have the file. Then we directed the member secretary to ensure that no convict remains in jail unrepresented. Thereafter, again after 2 months, a matter again came up before the division bench with a delay of 1,508 days. This continued again after 2 months with 2,346 days. Again next month with 807 days. Finally, we brought it to the notice of our patron-in-chief. A circular was issued to all the secretaries, legal service authority, and to our utter surprise, as many as 107 appeals were filed. So we have come a long way since last so many years. Despite the strides we have made, it is important to acknowledge that our journey is far from over. Challenges persist, and there is still much work to be done to bridge the gap between the legal framework and its effective implementation. Resource constraints, awareness gaps, and institutional capacity issues continue to pose obstacles in our quest for equitable access to justice. Today's colloquium provides us with a platform to delve into complexities of access to justice and legal aid services in our society. It offers us an opportunity to critically examine the challenges faced by marginalized communities and vulnerable groups in availing legal assistance, while also exploring innovative solutions and avenues for enhancing accessibility. I once again extend a warm welcome to all our distinguished guests, esteemed colleagues and participants. May our deliberations today pave the way for a more just and equitable society for all. Thank you. Jai Hind.
Thank you, Lordship, for your warm welcome and setting the tone of the seminar. Absolutely correct. Honorable Mr. Justice Manindra Mohan Srivastav, Chief Justice of Rajasthan High Court and Patron-in-Chief of Rajasthan State Legal Services Authority, epitomizes judicial excellence with erudition and integrity. Lordship's commitment to legal aid services and Lok Adalat is unparalleled. May I request the Lordship, Honorable Chief Justice of Rajasthan, for the introductory address. Sir.
Good morning and Khammagadi. Honorable Mr. Justice Sanjeev Khanna, Judge Supreme Court of India and Executive Chairman, National Legal Services Authority. Honorable Mr. Justice Sandeep Mehta, Judge Supreme Court of India and son of this soil, who is representing the legal fraternity of this state in the Supreme Court. My brother Justice Pankaj Bhandari, Judge Rajasthan High Court and Executive Chairman, Rajasthan State Legal Services Authority. Brother Justice Pushpin Singh Bhati, Judge Rajasthan High Court and Chairman Rajasthan High Court Legal Services Committee at Jaipur. My esteemed brother and sister judges in the Rajasthan High Court. Learned senior advocates, Vice Chairman and members of Bar Council of Rajasthan, presidents and office bearers of Bar Associations of Jodhpur and Jaipur, officers of the Registry, Rajasthan State Legal Services Authority and State Judicial Academy, chairmen and secretaries of district legal services authorities in the state of Rajasthan, panel lawyers, paralegal volunteers, ladies and gentlemen. It's my proud privilege to extend hearty welcome and warm felicitation to the distinguished gathering on this event of one-day colloquium on legal aid and social justice, challenges and opportunities in access to justice, which is being organized as a part of Platinum Jubilee celebration to mark 75th year of Rajasthan High Court, which was established by Rajasthan High Court Ordinance 1949 and was inaugurated in Jodhpur on 29th of August 1949 by Maharaja Savai Man Singh, the Raj Pramukh of the state of Rajasthan. Ever since then, it has emerged as a glorious institution devoted to the cause of justice through untiring efforts of the judges and lawyers with solemn resolve to strengthen the confidence, trust, and faith of the people in the judiciary and to accomplish the vision of ensuring justice for all. Committed efforts are being made to make the justice delivery system easily accessible, affordable, and understandable to the common man, especially to those belonging to the poor, downtrodden, vulnerable, and marginalized groups, thereby taking the institution to greater heights. Celebration of Platinum Jubilee of any institution is a remarkable event in the history of such institution, but then it is also an occasion, an opportunity to introspect, learn from past experience, and plan future actions and endeavor. Our founding fathers were aware of prevailing inequality in the society on the day we attained freedom. Therefore, preamble to the Constitution of India is an expression of our collective resolve to secure social justice to all the citizens. And it is manifested in letter and spirit in Article 39A of the Constitution of India, which mandates that the state shall secure that the operation of the legal system promotes justice on the basis of equal opportunity and shall, in particular, provide free legal aid by suitable legislations or schemes or in any other way to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disability. By enacting Legal Services Authorities Act 1987, people, through their representatives in the legislature, repose great confidence in the judiciary by assigning to it lead role in providing legal services so as to ensure access to justice for all. Social justice and legal aid are deeply interconnected pillars of a fair and equitable society. At their core, both concepts are rooted in the principle of ensuring equal rights and opportunities for all individuals. This synergy between social justice and legal aid services underscores the importance of maintaining a legal system that is accessible, fair, and responsive to the needs of all individuals, especially those who are marginalized or disadvantaged. Access to justice is not just a theoretical concept, but rather a fundamental pillar that upholds the foundation of democracy. It is the bedrock of our society's collective belief in the rule of law, ensuring that every individual, regardless of their background or circumstances, has the opportunity to seek redressal for grievances and assert their rights before a court of law. However, despite the noble ideals enshrined in constitutional and legal framework, that is under Article 39A of the Legal Services Authorities Act, and other rules and regulations, the reality, we must admit and confess, falls short of the aspirations we hold eligible. Millions of our fellow citizens, especially those from marginalized communities and vulnerable groups, continue to face formidable barriers in accessing legal aid and securing justice. It is incumbent upon us to confront these challenges head-on and strive for a more equitable and inclusive system of justice for all. Today, as we convene to deliberate upon the challenges and opportunities in access to legal aid, let us first take stock of current landscape. Identifying the challenges faced by marginalized communities and vulnerable groups is not just crucial, but imperative in our mission to address disparities in accessing legal aid services. Women, children, prisoners, persons with disabilities, and other marginalized and weaker sections of society often confront unique legal needs that demand specialized assistance. However, these are very individuals often find themselves distanced from legal aid services due to myriad and interconnected factors. Financial constraints pose a formidable barrier, making legal aid services inaccessible to a substantial portion of the population. Additionally, there persists a glaring lack of awareness about their legal rights and the availability of legal aid services amongst these vulnerable population. This ignorance, compounded by discriminatory attitudes and practice within the legal system, further exacerbates their marginalization. Furthermore, limited resources and capacity with legal aid organizations do hinder, to some extent, if not entirely, the ability to adequately reach and serve marginalized communities. The organizations often grapple with high caseloads, understaffing, and inadequate funding, constraining their ability to provide comprehensive assistance. The challenges are particularly pronounced for rural populations and those residing in remote areas. Geographic isolation, coupled with a dearth of infrastructure and a shortage of legal professionals, creates significant obstacles in accessing legal aid services. For many in rural areas, the nearest legal aid center may be situated miles away, making it practically inaccessible for those without means of transportation. Even if individuals manage to overcome these barriers and reach a legal aid facility, they may find it understaffed or ill-equipped to meet their needs. At times, we have received inputs that there is lack of sensitivity also while interacting and dealing with those persons. This geographical divide perpetuates a cycle of exclusion, leaving rural communities underserved and their legal needs not met with adequately. Additionally, the cultural and linguistic diversity of rural population adds another layer of complexity, often requiring tailored approaches to communication and service delivery. Addressing these multifaceted challenges demands a concerted effort aimed at raising awareness, eliminating systemic discrimination, and enhancing the capacity and resources of legal aid organizations. Moreover, it necessitates innovative approaches to service delivery that are sensitive to the unique needs and circumstances of marginalized communities. Only through collective actions and unwavering commitments can we bridge this divide and ensure that justice is truly accessible to all, irrespective of their socio-economic status or geographical location. It is imperative that our legal aid services meet these specific needs, ensuring that no one is left behind. Not only this, but our aspirations must extend far beyond mere accessibility. Legal aid must also serve as a potent instrument for addressing systemic injustices. It is not enough to provide redressal for individual grievances. We must strive to dismantle the structures that perpetuate inequality and oppression. This requires a holistic approach that combines legal advocacy with grassroots mobilization, aiming not just for case resolution, but societal transformation. Our agenda today encompasses a comprehensive exploration of innovative solutions to enhance the accessibility of legal aid services. We must constantly reassess and refine our strategies in our quest for excellence. Enhancing the effectiveness and efficiency of legal aid institution is an ongoing endeavor that demands our unwavering commitment. From streamlining process to leveraging partnerships with civil society organizations, we can bolster our endeavors and efficacy in myriad ways. As we embark on this collective journey towards a more just and equitable society, it is essential to recognize the pivotal role that each one of us plays in shaping the future of our legal system. Whether as judges, lawyers, policymakers, or concerned citizens, we all have a stake in ensuring that access to justice is not a privilege reserved for the few, but a universal right upheld for the many. Prevailing socio-economic barriers pose formidable challenge to legal services institutions established under Legal Services Authorities Act 1987. National Legal Services Authority and state legal services authorities, as also district as well as taluka level authorities, are engaged in formulating and implementing various schemes across the country. Sensitization and commitments of all stakeholders is essential to achieve constitutional goal of access to justice for all. We have been engaged in creating awareness and outreach programs, organizing camps in remotest areas, holding lok adalats, and various other activities towards legal aid. It requires collective resolve and concerted efforts. I must disclose to the gathering here that it's not that the Honorable Executive Chairman NALSA is with us only today in the morning. I must tell you that the Honorable Chairman has been here and camping for the last 2 days, and he has been interacting with the lowest rungs in the society. He had been to villages, He had gone to Talika Services Authorities offices to find out how they are working, how they are functioning. Honorable Chairman had also gone to the jails here yesterday. He interacted with the inmates of the jail, men, women, everyone, to find out as to what is the ground reality and how are we functioning, only in order to reassess, to have a self-audit in order to know how our schemes, how our various programs are reaching to the common man or to the person who the beneficiaries. Maybe in the jail, poor people who are in need of legal aid, etc. And that has motivated to a great extent to all in the legal services in the state as to how to go ahead with our legal services activities. It's not enough that we are collecting papers, finding out as to what is there on papers, but also to look into how these schemes and programs are actually reaching the beneficiary in the manner and as was envisaged in our schemes. In conclusion, I am reminded of the words of Mahatma Gandhi, who once said, "A nation's greatness is measured by how it treats its weakest members." These words resonate deeply with the theme of our colloquium today, highlighting the intrinsic connection between access to justice and social justice. Let us seize this opportunity to engage in meaningful dialogue, exchange ideas, and chart a course of action that reflects our shared commitment to justice and equality. Together, let us confront the challenges, embrace the opportunities, and strive towards a future where legal aid promises are fulfilled for every individual, regardless of their circumstances. Thank you. Jai Hind.
Thank you, Lordship. Your views are subtle and the message in it is dynamic and effective. Honorable Mr. Justice Sandeep Mehta, Judge, Supreme Court of India, as Honorable Justice Manindra Mohan Srivastava sir said, is a son of the soil. Lordship is a true Rajasthani, representing patriotism, cultural values, ethos, and law administrative abilities. An expert in criminal and constitutional matters, Mr. Justice Sandeep Mehta had been one of the most eminent, articulate, and the finest judges of Rajasthan High Court. For 13 years, many still refer to the judgments and views expressed by Lordship. As the judge of Rajasthan High Court, Lordship was also the Chief Justice of Guwahati High Court. May I request Lordship to share his special address with the august audience.
My greetings to all on the Rajasthan Divas. My esteemed brother, Honorable Justice Sanjeev Khanna, Judge Supreme Court of India and Executive Chairman NALSA, I would welcome him to Rajasthan with the words, "Padharo Mare Desh." Honorable the Chief Justice, Justice Manindra Mohan Srivastava, Patron-in-Chief RSLSA, my esteemed brother, Honorable Justice Pankaj Bhandari, Executive Chairman RSLSA, my brother, Honorable Justice Dr. Pushpendra Singh Bhati, Rajasthan High Court Legal Services Committee, Jaipur, my esteemed sister and brother judges from the Rajasthan High Court, learned senior advocates, members of the Bar Council of Rajasthan, office bearers of the Advocates Association from Jodhpur and Jaipur, chairpersons, DLSA, secretaries, DLSA, learned judicial officers, members of the bar, paralegal volunteers, law students, gracious ladies and gentlemen. I feel it an honor and a privilege to share the dais with my esteemed brother, Honorable Justice Sanjeev Khanna, in this ongoing session of celebrations of the Platinum Jubilee of my parent High Court, the Rajasthan High Court. Honorable the Chief Justice has assigned me the task of speaking on examining the role of legal education in fostering a culture of legal aid and discussing the ways to integrate legal aid principles into law school curriculum. Justice, my friends, should not be a privilege reserved for the wealthy, but a right accessible to all. And that's why legal aid stands as a beacon of hope for those who are unable to afford legal representation. In the Indian context, where despite all the progress and growth that our republic has undergone since independence, the socio-economic disparities are still apparent and serve us a reminder that the need for accessible and free legal aid is very crucial. When we talk of legal aid, I do not refer to it as a mere form of service, but as a very fundamental aspect of our constitutional morality. Ensuring that every individual, regardless of their background, has the opportunity to seek justice and uphold the rights which are guaranteed by the Constitution and the laws. I must state that the legal aid pivots around empowerment. By empowerment, I mean empowering individuals to assert their rights without fear that they will have to navigate the complex legal systems for seeking redressal of their grievances. However, in order to truly enable this concept, we must recognize the important role of legal education in shaping the lawyers who facilitate this culture. Law schools serve as the training ground for the future legal professionals. And as far as I have understood, in my years of practice as an advocate and later as a judge, law schools are not only responsible for imparting students with quality legal knowledge, but rather, very importantly, with a sense of responsibility towards the society. This sense of duty, integrity, and commitment towards the society stemming from the profession is something that should be integrated actively into the education system. In a review of the legal education undertaken by the UGC, Professor Upendra Bakshi discussed the expression social relevance with insight, which holds significance even as on date. And I quote, social relevance requires at least that a curriculum cognizes the principal contemporary problems and corresponding tasks before the law and the lawyers. Can a law curriculum be socially relevant and yet ignore the fact that India is an overwhelmingly a rural economy, or that it is a country full of underprivileged exploitation and destitution? Unquote. The genesis of free legal aid in India could be traced back to the 42nd Constitutional Amendment 1976, which introduced Article 39A to the Indian Constitution. This strived for dispensing away economic or other disabilities from availing what is justly due to one under the wider sweeps of justice. This provision was effectively put to function in the case of Husainara Khatun, where the Supreme Court chastised the state for treating under trials for minor offenses as mere ticket numbers on account of being poor, and ordered the state machinery to bring life to the Article 39A by compulsorily providing lawyers to such people. By stretching this principle further, in Maneka Gandhi, Honorable Justice Bhagwati observed, this article also emphasizes that free legal service is an inalienable element of reasonable, fair, and just procedure, for without it, a person suffering from economic or other disabilities would be deprived of the opportunity for securing justice. The right to free legal services is therefore clearly an essential ingredient of reasonable, fair, and just procedure for a person accused of an offense, and it must be held implicit in the guarantee of Article 21. This is a constitutional right of every accused person who is unable to engage a lawyer and secure legal services on account of reasons such as poverty, indigence, or incommunicado situation, and the state is under a mandate to provide a lawyer to an accused person if the circumstances of the case and the needs of justice so require, provided, of course, that that the accused person does not object to the provision of such a lawyer. Extending the principles further in Khatri versus State of Bihar, while rejecting an argument espousing financial constraints as a reason for failing to provide free legal aid to the accused, Justice Bhagwati observed, we may point out to the State of Bihar that it cannot avoid its constitutional obligation to provide free legal services to a poor accused by pleading financial or administrative inability. The state is under an obligation, under a constitutional mandate to provide free legal aid to an accused person who is unable to secure legal services on account of indigence, and whatever is necessary for this purpose has to be done by state, unquote. The Supreme Court has in innumerable judgments unequivocally asserted for provision of free legal aid. These views of the Supreme Court led the Parliament to enact the Legal Services Authorities Act in the year 1987. The present model of legal aid in India is set out in the Legal Services Authorities Act, which provides for the National Legal Services Authority at the national level, headed by Honorable the Chief Justice of India as its patron-in-chief, and Honorable Senior Most Judge of the Supreme Court immediately next in seniority to the CJI as its executive chairman. This model is replicated in all states and bodies, and the bodies so constituted are referred to as the State Legal Services Authority. Now, let us shift our attention to the issue as to how we integrate the legal aid principles into our law school curriculum. To answer this, we must adopt a multifaceted approach. This takes into consideration the unique needs of the country. We should instill a sense of social justice and empathy in our students via legal education. This concept should not be confined to statutes and case laws, but also encompass the ethical imperative of serving the marginalized and the vulnerable people. Incorporating real-life case studies and practical experiences into the curriculum. Collaboration with the legal aid organizations and practitioners to provide students with the experimental learning opportunities. Mandatory participation in pro bono initiatives, not only to benefit the community, but also to equip the students with the skills and the mindset necessary to be effective advocates for justice. Bridging the gap between theory and practice. Leveraging technological advancements to expand the reach of legal aid. For this, the online platforms, websites, apps, etc. can be used for providing assistance to remote and underserved communities. We had this experience in Arunachal, where the access to the paralegal volunteers or the legal service authorities is very difficult because of distances. There, the online platforms and the internet facilities are very useful. Integration of the legal aid principles into law school curriculum by actively promoting legal aid clinics. There are three parameters for this: the legal aid clinics, the paralegal volunteers, and integrating the social justice perspectives. Legal aid clinics play a vital role in the maintenance of the rule of law. Law school, being the recruiting ground for the legal profession, need to inject new spirit into the content of legal education to make the lawyers and the legal professionals socially relevant and professionally competent to secure the constitutional mandate for access to justice. Therefore, the ethical responsibility of the law schools is not limited to the students or the professionals, but it is also towards the citizen who depend upon the law. Now, what is the significance of the legal aid clinics? R. Grimes, a well-known author, defines law clinics as, I quote, a learning environment where students identify, research, and apply knowledge in a setting which replicates, at least in part, the world where it is practiced. It almost inevitably means that the students take on some aspect of a case and conduct this as it would be conducted in the real world, unquote. Therefore, the legal aid program, which is meant to bring social justice to people, cannot remain confined to traditional or litigation-oriented program, but it also must take into account the socio-economic conditions prevailing in the country and adopt a more dynamic approach. The Supreme Court in the case of State of Maharashtra versus Manubhai observed, in order to enable the state to afford free legal aid and guarantee speedy trials, a vast number of persons trained in law are essential. Legal aid is required in many forms and at various stages for obtaining guidance for resolving disputes in courts, tribunals, or other authorities. Legal education should be able to meet the ever-growing demands of the society and should be thoroughly equipped to cater to the complexities of the different situations, unquote. The enactment of the Legal Services Authorities Act 1987 entitled more than 60% of the Indian population to free legal aid. With such a huge number of claimants, it became very difficult for the states to offer quality legal aid. In this scenario, the legal profession is expected to play a dynamic and a vital role. The Bar Council of India in the year 2008 approved the rules on standard of legal education and recognition of degrees in law. These rules mandated all the law colleges to establish and run a legal aid clinic under the supervision of a senior faculty member. In the year 2010, the Bar Council reiterated the same in its Inspection Manual 2010. The National Legal Services Authority Legal Aid Clinic Scheme 2011 is also relevant and requires the institutions that function with the coordination of the state legal services authorities. Our legal education places considerable emphasis on the clinical legal education so that the students can learn the law while acquiring the professional skills. Therefore, the student's exposure to the real legal problems has mutual benefits to the students, to the legal aid schemes, and to the legal system in the following ways. The law students can extend legal aid to the remote villages. Students can provide legal aid and advice without any significant expenditure. Legal aid cells are an excellent means of teaching professional responsibility. Legal aid cells provide an ideal platform for the students to learn practical skills. Involving law colleges also improves the value and reputation of the legal profession. Now, what are the issues and challenges to the legal aid clinics? A study supported by the Government of India and the United Nations Development Programme, titled as Project on Access to Justice, found that nearly 82% of the colleges have assigned faculty to conduct the legal aid activity, yet it is not effective because legal aid activity is still a non-credit extracurricular activity in the Indian law schools. There are several factors responsible for this. The first is lack of resources and funds. The second is no credits for the voluntary work, lack of adequate training, and the legal obligation. Legal aid clinics, my friends, were started merely to satisfy the mandatory requirements by the Bar Council of India, and most of the activities have been restricted to organizing a few legal literacy camps. Now, what can be the suggestions to improve this system? The first would be a separate faculty. The faculty should be appointed specifically for the purpose of legal aid work, as it requires long working hours and continuous supervision, mentoring and guidance of the students. However, it is easier said than done because as we all know that the law schools are running short of regular faculty members. So it is for the National Legal Services Authority to find out ways how to provide the faculty members for the purposes of extending education of legal aid to the students. Funding. The adequate funding should be available for the successful running of these clinical programs. Continuous training, outreach programs, research activities, and delivery of effective legal services are affected because of paucity of funds. The state governments and the central government can be asked to contribute more in this field. I may also share with the Executive Chairman that there are states where the funds which have been assigned to the State Legal Services Authority are not being utilized. Perhaps there can be a way to devise the some of the funds to be reappropriated for these legal aid clinics in the colleges. The third would be training programs. Training of the students should be held at the regular intervals so as to hone their skills and awareness. That should be the norm rather than an exception. Model institutions. The UGC should look at some model institutions that have exceptionally good clinical activities and have trained clinical faculty members and use these models as a basis for curriculum for the faculty development course in the clinical education. Networking. Proper networking needs to be developed amongst the clinics to involve the students and the faculty members with the other stakeholders on a single platform so as to share the experiences and the best practices amongst the law schools. Credits or rewards for their voluntary works. Students need to be given some credits for their legal aid work in the universities. Most of the law schools give credits to the students for the legal aid work. Presently in these universities, the students doing the legal aid work end up being penalized for the same at times because of the nature of their work. They have to forego their classes and can be detained for being short on attendance. A system of reward and recognition of services of those who do the pro bono work and are willing to help the indigent and the needy to secure justice should be introduced. The alumni network. The alumni base of the institution should be properly utilized. That is, the ex-students who are actively practicing before the courts should be involved so as to help the students with the free legal aid clinic scheme. The most important cog in the wheel of the Legal Services Authority are the paralegal volunteers. The paralegal is one who works in the legal field but is not a qualified lawyer. Paralegals bridge the gap between the community, lawyers, and the judicial system. They help in the dissemination of legal information, follow-up cases. They can help in the pre-litigation work, which is very crucial, and if not done well, could affect the case adversely. Paralegals are placed at the heart of the legal aid scheme under the Legal Services Authorities Act 1987. Paralegal volunteer means a volunteer trained as such by a legal services institution. But again, there is an issue. The eligibility criterion, the responsibilities, training and remuneration of paralegals are either not provided in the Act or the regulations or are not up to the mark. Indian Institute of Paralegal Studies attempted to define the functions of paralegals, which goes on to show their great significance in the entire functioning of legal aid in the country. The study highlighted the following issues. First, the delivery of services. A paralegal is trained to do the pre-litigative work like support in investigation and fact-finding, out-of-court settlements with a rights perspective, filing of FIRs, etc. Also, once a court order has been obtained, the paralegal is involved in ensuring proper implementation of the order and to take necessary steps for the same. Education and awareness. A paralegal is involved in bringing about legal awareness in the masses through means like community education programs. They educate people about what their rights are and motivate them to fight for their rights. Updating the community dispute resolution system. Paralegals play a vital role in revamping the existing dispute resolution mechanism and add a legal and a rights perspective to it. Therefore, the institutions should actively encourage and partner up with the National Legal Service Authority to conduct training sessions for the students to become the paralegal volunteers. Now, we have to integrate the social justice perspectives. The integration of these perspectives in the law school syllabus is very important for several reasons. The first would be understanding the context of legal issues. The social justice perspectives provide the students with a broader understanding of the social, economic, and political context in which the legal issues arise. By examining the underlying structural inequalities that contribute to the legal problems, the students can develop a better understanding of the law and its impact on the marginalized communities. Promoting access to justice. Social justice perspectives highlight the importance of addressing the systemic barriers to the access of justice, particularly for the marginalized and the disadvantaged groups. By incorporating these perspectives into the curriculum, the law schools can prepare the students to advocate for policies and practices that promote equal access to the legal resources and services. Fostering empathy and cultural competence. Learning about the social justice issues help students develop an empathy for the individuals and communities which are affected by injustice. It also fosters cultural competence by encouraging the students to consider the perspectives and experience of the people from diverse backgrounds. This empathy and cultural competence are essential. These are essential qualities for effective legal professionals who must understand and serve the needs of a diverse client base. Preparing ethical and responsible legal professionals. Integrating social justice perspectives into the curriculum reinforces the ethical responsibilities of the legal professionals to promote justice and equality. It encourages the students to reflect on the ethical dimensions of their work and to consider the broader social implications of the legal decisions. This prepares the graduates to navigate ethical dilemmas with a commitment to advancing social justice principles. Addressing contemporary legal challenges. Many contemporary legal issues intersect with social justice concerns, such as racial justice, environmental justice, gender equality, and economic inequality. By incorporating social justice perspectives into the syllabus, the law schools can equip students with the knowledge and skills needed to address these, these pressing challenges effectively. Overall, integrating social justice perspectives into the law school syllabus is very essential for preparing students to be competent, ethical, and socially responsible legal professionals who are equipped to address the complex challenges of a diverse and a rapidly changing world. As they say, well begun is half done. So my thinking is that the concept of free legal aid, which is founded in Article 39, is made a part of the school curriculum, because children, if of the school level, if this thought is instilled in them at that stage, it would really take their thinking for providing the legal aid to the needy to a greater level. In conclusion, I would say the integration of legal aid principles into the law school curriculum is not only a pedagogical necessity, but a moral imperative for fostering a culture of justice and equity. As we reflect on the role of legal education in nurturing future legal professionals, it becomes evident that instilling a sense of social responsibility, empathy, and commitment to serving the marginalized communities is of paramount importance. Legal aid clinics, paralegal volunteer programs, and the integration of social justice perspectives offer promising avenues for bridging the gap between legal education and the needs of the society. As we move forward, let us reaffirm our commitment to fostering a culture of legal aid through education, thereby advancing the cause of justice and promoting common good in our society. Before I give rest to my address, I would respond to Brother Justice Pankaj Bhandari's observations. He referred to the appeals which have been received in the Rajasthan High Court after a gap of 6 years, 8 years, 10 years. I would like to share with Honorable the Executive Chairman that while I was serving the Rajasthan High Court, we had taken up this issue on the judicial side, and we had collected the data of all prisoners in the state of Rajasthan, and we had integrated it, merged it into a statistics which had been then brought onto a platform known as e-prisons. And that statistics, sir, had got all the parameters regarding whether the convict has filed an appeal or not, whether the convict has been given the due consideration for grant of parole on becoming entitled, whether the convict on becoming entitled to be sent to the open air camp has been considered for that or not. Honorable Justice Farzan Ali was the Additional Advocate General at that time, and his contribution to creation of this platform was great. Probably these instances are a reminder of the fact that that e-prisons facility, that app and the statistics which we had collected needs to be updated. I would also like to share with Honorable the Executive Chairman that I was being told about the pro bono counsel system, and Rajasthan stands proud because out of the 8,000 odd pro bono counsels in the country, 1,300 odd are from Rajasthan. I would also like to share that when I was the chairperson of the Rajasthan State Legal Services Committee, Jaipur, I had requested the senior counsels, designated senior counsels, to offer their pro bono services. And sir, each one of them had given their consent to be appointed as a pro bono counsel in any matter which the court assigned to them. So all designated seniors in Jodhpur at least are now enrolled as pro bono counsels under the Legal Services Committee. Most probably the same must have been replicated in Jaipur, and if not, it can be done now. Now, what is the satisfaction of acting as a pro bono counsel? I'd like to share with this august audience. My first brush with acting as a pro bono counsel came in the very first year of my practice. And the satisfaction which I had, that is now virtually ingrained in my system. The matter was in the office of my late senior, Honorable Sri D.S. Shishode Advocate. A vision impaired person had been denied appointment in the railways. I still remember his name. His name was Kalamuddin. He came to the office with a grievance that he has been denied appointment despite his appointment, the selection process, only on the count that he was a vision impaired man. The post was of an announcer. So I contested that case, of course pro bono, in the CAT and got him the relief. And he was appointed as an announcer in the railways. Whenever we went to the railway station at Jodhpur, we would hear his voice. And that gave me an immense satisfaction that perhaps my pro bono services has given respite to a man who truly deserved the same. So friends, the lawyers, the students who are there, I can tell you that there cannot be any greater satisfaction of a law professional of giving the services to a truly needy person as a pro bono counsel. My sincere thanks to Honorable the Chief Justice for having given me this opportunity of sharing the platform with my esteemed brother, Honorable Justice Sanjeev Khanna, in the celebrations of my parent institution, the Grand Rajasthan High Court. Thank you. Jai Hind.
Thank you, Lordship, for indeed a profound special address. We now move to the launching session of Rajasthan State Legal Services Authority's two books. The first is Bal Rachnai. As the name suggests, it's a compilation of state-level winner entries for story writing, essays, and poems organized by RSLSA amongst the children residing in various children homes and shelter homes and others. We at RSLSA believe that writings from the heart by those who are trying to regain their childhood and with the hope of a bright future is a treasure to have. I request dignitaries on the dais to please launch the Bal Rachnais. Thank you, Lordships. Now we come to the release of Action Plan 2024-2025. Every year, RALSA meticulously drafts its action plan detailing a comprehensive roadmap for activities, awareness and campaigns, and drives executed by legal services institutions across Rajasthan. Similarly, the action plan for 2024-2025 is prepared as a visionary document that will reflect our unwavering dedication to serving the community marginalized and vulnerable sections and enduring unfettered access to legal services. Thank you, Lordships. Moving further, and it's very interesting. Artificial intelligence, or AI, as it's called, is transforming the world completely. AI, the technological inflection point, will affect nearly every aspect of the human life. Chatbot, short for Chatterbot, is an AI feature that is proving to be the fastest and the most convenient to interact with others. RALSA's endeavor to providing legal aids in the fastest way has led to the creation of Chatbot. It will enhance efficiency by automating response and solutions, thus leading to time and cost saving. It will ensure legal accessibility to the last mile. Ladies and gentlemen, RALSA takes pride in launching its Chatbot in this August audience. I request Mr. Justice Sanjeev Khanna to launch RALSA's legal aid Chatbot.
राजस्थान राज्य विधिक सेवा प्राधिकरण राज्य में विधिक सेवाओं में तकनीकी नवाचार कर न्याय सबके लिए की अवधारणा को नए सिरे से परिभाषित करने के लिए प्रतिबद्ध है। इसी दिशा में रालसा ने एआई का उपयोग करके जन सामान्य तक विधिक सेवाओं की पहुंच सुनिश्चित करने और उन्हें जागरूक करने के लिए एक चैटबॉट विकसित किया है। यह चैटबॉट एक वर्चुअल असिस्टेंट है जो विधिक सहायता से जुड़ी सभी जिज्ञासाओं का उत्तर खोजने में सहायक है। हमारे लिए हर्ष और गौरव की बात है कि रालसा के इस चैटबॉट को आज माननीय न्यायाधिपति श्री संजीव खन्ना साहब, न्यायाधीश उच्चतम न्यायालय एवं कार्यकारी अध्यक्ष राष्ट्रीय विधिक सेवा प्राधिकरण नई दिल्ली के कर कमलों द्वारा लॉन्च किया जा रहा है। रालसा के इस विधिक सेवा चैटबॉट की खासियत है कि यह विधिक सेवाओं तक पहुंच की प्रक्रिया को आसान करता है, जिससे यूज़र को कुछ ही क्लिक के साथ कानूनी सहायता सुलभ हो जाती है। इसका इंटरफेस हिंदी और अंग्रेजी दोनों भाषाओं में तैयार किया गया है। यह किसी भी समय कहीं भी यूज़र के प्रश्नों का तत्काल उत्तर देने के लिए तैयार है। इसमें एक उन्नत सर्च इंजन भी दिया गया है। यह चैटबॉट एडवांस्ड एल्गोरिदम द्वारा संचालित है। हमारा संकल्प है कि इससे सटीक और विश्वसनीय जानकारी उपलब्ध हो सके। इस चैटबॉट के साथ यूज़र की सभी बातचीत पूरी तरह से गोपनीय है। हमारा लक्ष्य है कि आम जन की आवश्यकताओं के अनुरूप इस चैटबॉट में नई सुविधाओं को शामिल कर इसकी क्षमताओं को और अधिक विकसित और विस्तारित किया जाए। धन्यवाद।
Thank you very much. Honorable Mr. Justice Sanjeev Khanna, Judge Supreme Court of India and Executive Chairman NALSA, has always championed the legal aid that goes beyond assisting the needy of justice. As he believes, as Lordship believes, that it plays a functional role in enhancing the justice system. Honorable Mr. Justice Khanna's perspective underscores the importance of understanding legal aid as a mechanism that empowers individuals to engage with public institutions, promotes access to justice, and ensures quality representation. It's a privilege that Lordship is amongst us. May I request Lordship to enlighten us with your keynote address.
I'm very happy and consider it to be privileged to be present here today on your Platinum Jubilee celebrations, and that too on the topic which is very dear to all of us, access to justice. After all, when we are in the courts, what are we doing? We ensure giving and ensuring justice to everybody. Justice is not possible until unless you have excess. They are so much interconnected that sometimes we fail to appreciate and understand that without excess, justice cannot be delivered to the ones who most are in need and requirement of justice. My brother, Mr. Justice Sandeep Mehta, the Chief Justice of Rajasthan High Court, Mr. Justice M.M. Srivastav, Mr. Justice Pankaj Bhandari, Mr. Justice P.S. Bhatti, sister and brother judges from the Rajasthan High Court, senior advocates and the members of the bar, dear students, members of our family of legal aid, namaste and good morning. After I got associated last year with the legal aid, I had made a slideshow which over the period of time I have moderated and improved and changed. I thought I'll share with you the same slideshow with some differences here and there to point out what is happening in legal aid. Legal aid in India, perhaps we are the front runners in the world. We don't recognize that. Almost 80% of 1.4 billion people are entitled to legal aid in India. Entitlement is one thing and need for legal aid is something different. So one must keep that in mind. Almost 30% of the trial court cases are being handled by legal aid councils in India, and the figure goes to 50% when it comes to appellate court. In fact, when we refer to these figures to most of the Western persons who have come from the Western world, they're quite surprised. Legal aid in several countries in appeal level is very difficult to get. After a person is convicted, many countries, the taxpayers don't agree that the legal aid should be provided to a person who is convicted and sentenced. But we do it, and we do it with a sense of pride that we are a system which is governed by rule of law, which ensures that legal aid is provided to everybody who needs it. Nobody is deprived of the fact mainly because he's been convicted. This slide gives you a brief idea of the advocates we have, how many state legal services authorities we have in order to be able to deal with legal aid at such humongous level. I'll pause here for a minute because normally we consider legal aid as legal aid only given in the courts in the form of free lawyer or an advocate to appear for you. But it's much more than this. As I'll go through the slides, you'll realize it's much more than this. We are giving assistance, not only legal assistance, but also assistance to be able to the citizens who are in need and requirement and do not have access, so that they can get benefit of various schemes floated by the government and by us. It's much more, therefore our task is far more challenging. As was rightly pointed out, we have these paralegal volunteers. On the panel of all India level, we have about 46,412 panel advocates and about 42,782 paralegal volunteers. I'll pause here for a minute. After having taken over as an executive chairperson, I realized there are certain points or certain issues which require attention. One is paralegal volunteers. I'll be dealing with this in some detail because this, I feel, has to be taken up at a higher, much higher level. The second issue which I feel we have to address is early access to justice, that is making available legal assistance at pre-arrest and arrest and the remand stage. Remand stage we have in fact been able to get some results, but it is at the pre-arrest and the arrest stage where we are lacking behind and are in a slight problem. The other two aspects where I feel legal aid has to be also, or our legal services authorities have to activate, is with regard to release of under trial prisoners, where they can get benefit of any other schemes or remission or premature release. Probation of Offenders Act is virtually not being applied. So these are two areas where we have to do. The third, last aspect on which I want to lay some emphasis is on mediation. I think future of litigation will be mediation in India as it has happened abroad. We are not realizing it, but future of litigation, given a size, we have about 26,000 judges, about 1,000 High Court judges. How can they resolve disputes of the population of our size? It's impossible. And why should everybody come to court? Recently, a group of mediators, lawyers came to me and they said, we are now given up law practice. We have now become professional mediators. And we charge substantial amount for doing mediation. I was happy also, and because they wanted NALSA to come in, I was reluctant also, because I can't promote a particular group. But the fact of the matter is, baby steps have been taken towards mediation as a profession, independent, in addition to being a lawyer. We have come across terms which are very often used abroad, med-aap, aap-med, etc., which means integration of mediation and arbitration. We also know of several cases, at least as far as family matters is concerned, where mediation has been extremely successful. I'll refer to those figures a little later and what I intend doing with regard to mediation, so to enable advocates as well as laypersons to become mediators. As far as the glimpse of the legal aid in Rajasthan is concerned, we have about 1632 panel lawyers, out of which 139, which is 10%, are in the High Court. The rest of them are in the district courts. We have paralegal volunteers of 1,333, of which 28%, that is 372, are women. This number should go up because All India figure shows that 42% paralegal volunteers are women. But I'm very happy to see the figure is pro bono advocates, which Justice Mehta had also pointed out. You should be really proud of it, and I'm happy that the bar and the advocates realize their social responsibility. We have 1,198 pro bono advocates, out of which 973 are at the district levels and about 225, 19% at the High Court level. I think we have underutilized you. We must utilize you to the fullest ability. And I also propose, whoever does work, we must honor them and accept them by certifying that they have done this good work, who do the pro bono work. And that's where the youngsters at the middle level will feel encouraged to come in. Why do we require, because I pointed out, why do we require legal aid, and what is the philosophy behind legal aid? I think our constitution and the way we read the constitution forces us to accept legal aid, even to those who are in conflict with us or conflict with the society, have committed wrongs. And this is clear from our, Article 14, 21, 22. Already 38 and 39A have been referred to, but if you just go through Article 21(1), no person who is arrested shall be denied right to consult. Now, how does a person have right to consult until unless he's given an opportunity to consult or he has the economic means to consult? And to be defended by a legal practitioner of his choice. Choice doesn't exist if you don't have money. So how do we implement this article without legal aid? It's impossible. Article 14, state shall not deny to any person equality before law or equal protection of laws within the territory of India. How do you ensure equal protection of laws within the territory of India until unless you have a counsel who can defend you, who understand the nuances of law. Our laws are very complex. Let's be honest about it. Our laws are not drafted simply. They're too complex. Our judgments are also very complex. They are not written in plain and simple words. They are far more difficult. Even layman normally will not understand what is there in the law, what is there in the judgment. So your help is required. Our help is required. No person shall be deprived of his life or personal liberty except according to the procedure established by law. Now, over the period of time, we have dealt away with the controversy that procedure established by law has to be just and a fair procedure. That earlier controversy, procedure, the American view is this, that's all done away with. Procedure established of law has to be just and a fair procedure. And what do you mean by that? This slide gives you the ethos of our legal aid. Legal aid serves another purpose. When we have legal aid, we follow the letter of law. When we follow the letter of law, we uphold the rule of law. So it's one of the aids, one of the wheels which promotes and upholds the rule of law. It puts a check on arbitrary use of power. It checks the investigation process, improves quality of justice. We all want quality of justice. We want best quality justice. That's why we come to the courts. It instills confidentiality and credibility in the legal institutions. Without credibility and confidentiality in the legal system, obviously courts cannot work. Our acceptance, our goodwill is through that confidentiality, the confidence and the credibility which we enjoy in the society. This, I just refer to what is justice. Justice in one sense, I'm not saying in all senses, can be described as rules, as existence of rules that provide a fair and a just decision. Rules provide a fair, equal and a fair opportunity of winning against the powerful, most powerful, and against the state itself. This is the motto of when we go to the court. We all members, we have been associated with the courts. This, as far as courts is concerned, justice is embodied in this principle. Now there are three prongs of access to justice. One is legal awareness and literacy, because without that there cannot be access to justice. But the other three processes are ease of access. Once you've given them legal awareness and literacy is established, there has to be ease of access. They should be able to access and get hold. The second is early access, which I have already referred to. I'll be elaborating on it. The third aspect is quality of access. If legal aid is inferior, obviously, it's faulty. It's not going to serve its purpose. And legal aid is not available at the time when it should be given, again it will not serve its purpose. We'll be faltering if we have to scale it and point out whether we are successful in giving legal aid, we'll falter. Ease of access, again, we have to ensure that somebody should have the ease of access and immediate, when he requires it, he should be able to get it. Now, as far as tackling the apprehensions with regard to quality of legal aid is concerned, there are two concerns which we noticed after speaking to the under trials and the prisoners who are in custody. Many of them feel that we are arm of the state. Legal aid councils, when we go, we are arm of the state. Then they also raise the issue with regard to quality of the legal assistance being given. I think to a large extent, PLVs and the advocates who are appearing for us must dispel that fear that we are the arm of the state. We are not the arm of the state. We are different from, in fact, judiciary is not the arm of the state in that sense of the term, though we fall within as a third pillar, but we are the check on the other two, that is the legislature and the executive. When we file, the cases comes before us, it is state versus so and so. So state is one of the parties and the accused is the other party. So it's for you PLVs and the advocates who are on the panel, or LADC's counsels who have to dispel the figure. We also have to do it. We've tried to do it, but I think it's going to take some time. It's not so easy. The perceptions matter more than actual reality, but there may be some truth also in actual reality. The early ease of access and early access is raising awareness, and then we have the reach in and reach out approach. A reach out approach basically means we reach out to them. That's the way to go about, I think. We have to reach out to them. To expect them to come to us in most difficult times is possible, but they will be able to, there is some amount of reluctance. When you find that the person has been put behind, or the state is against you, the society is against you, person is reluctant to reach in to you. He's already in problem. He's emotionally, financially, absolutely under stress. So we have to adopt both reach in, reach out approach, but I favor reach out approach in most of the difficult circumstances. We must reach out to them. Now, this is, I come to the data with regard to what is the data we have with regard to the prisoners. In fact, this is 2022, 2023 data I've not been able to get through. It shows that the intake in the prisons is going up. It's not coming down. In fact, the other data, I have not got the slide, it also shows the number of bail applications being filed in the high courts across the country are going up. They're not coming down. So that means somewhere there is some problem which has to be tackled. Each one of you, probably all the judicial academies as well as the state committees, will have to put in their heads why it is happening. The total number of persons admitted to prison were 18 lakhs, whereas the total number who were released from prison was, you can take 17 lakhs. So there's a gap of 1 lakh. The other worrisome sign is that almost 76% in the prison today are under trials. The convicts constitute only 23.27%. Now this is a stigma. This figure is not good enough. In fact, I have the figures with regard to several Southeast Asian countries which are better than us. That cannot be accepted. We are responsible for it because we belong to the entire judiciary, consists of not only the judges but the lawyers, advocates. We are responsible for it. We have to somehow check that. There has been, as per this slide, 2.46% increase in 2022 compared to 2021. Now this figure is very interesting. This shows the total number of people who are in jail between 1 to 3 years, 3 to 5 years, and above 5 years. One hand, you can see the number is going up. This does not include people who have been in jail between 0 to 1 year. But above 1 year, the figure is going up. But the positive sign is, if you look at the, I had to look at the figure, I didn't have the figure for December 2022, but if you look at this figure, that almost 450,000 people are able to come out of the jail every year. Out of 550,000 who are in jail, 450,000 people come out of jail within 0 to 1 year. That's a good sign, because that means our judiciary is working, our advocates are working, they're working hard to ensure release of those prisoners. At least 450,000 prisoners are being released every year. The figures are not that disturbing here, because if we look at the population number of cases we have, 88,725 are between 1 to 3 years, 24,000 above, that is between 3 to 5 years, and just 11,500 above 5 years. So that's not very bad. And this is the total number. This includes the convicts also. So this number is not very bad. But I'll give you some other figures which are a little disturbing, which also shows there's a problem on our side. The reason why why so many people are going in the prison is that almost 1% of the Indian population is, can somebody help me? 1% of Indian population is arrested every year. Now, almost 69% of these arrests are under the CRPC provisions. They are not under the IPC provisions. So arrest doesn't mean they go behind prison. They are released on bail, many case time. But this means this is something which is disturbing. We have to put a check on it. It's not only in our hands, I think it's in the hands of the executive and the legislature also. But there is a problem on that. I referred to the part in my earlier speech that we have to, pre-trial stage, we have to improve our legal aid. Pre-trial stage can be divided into pre-arrest stage, arrest stage, and the remand stage. There have been very good legislative amendments made by the legislature in the form of section 41A of the CRPC, which mandates issue of notice to the accused at the pre-arrest stage. Provision for legal assistance at the pre-arrest stage entails the following benefits. The accused feels less isolated or intimidated, safeguards the accused's rights as per law, keeps a track on police aggression and abuse of power, avoids unnecessary address. It gives vital and time-sensitive information or evidence for suspect's defense is then protected. Protecting the suspect from being subjected to wrongful self-incrimination contrary to the constitutional and statutory provisions. What is most important is 41D, which we have not probably seen in proper perspective and applied it with all its rigor. Introduced in 2009, gives statutory recognition to the right of the legal assistance to a person when he is arrested or interrogated. So this is now a statutory right which has been given to any accused. This figure is a chart which gives you details, all India details. These are not Rajasthan specific details with regard to pre-arrest trial and stage. If you look at the figures of 2019, police in the suspects provided legal aid in prison was just 6,323. The figure has gone to 27,521, which is again not very high, but it is a substantial increase to 2023. The suspects not arrested because we gave them the legal aid in the prison was in 1919 was mere 1,546. It's gone to 9,948 in 2023. And arrested person given legal aid in the police station post the arrest, the figure has again gone up substantially. But the figure which is little better is the figure at the remand stage. Remand stage today, almost 1,70,000 people are getting legal aid at that time. But what is worrisome is that bail applications are being filed at the remand stage in only 66,000 matters. Much better than 20,745 in 2019, but a lot of work has to be done at this stage. Maybe the charges are very severe, so therefore it is not done, but we have to check out. We must get the breakup of the data to be able to show that how many were very serious charges and therefore they did not move. About 37,155 persons got bail at the remand stage. When we come to Rajasthan specific data, we have about 933 police stations. We have deployed PLVs only in about 202 police stations. 731 police stations, PLVs have not been deployed. This figure has to go up, must go up, if we have to tackle and deal with pre-arrest an arrest stage benefit. The number of suspects provided legal aid at the pre-arrest stage is 22. The number of suspects not arrested is 6. The number of arrestees provided legal assistance before producing them in court is 16. Legal assistance provided at remand stage is 1138. Number of bail applications filed at the remand stage is 532, in which the bail has been granted is 478. One thing is good, the cases in which we filed the bail applications, we were very successful. But these figures have to go up, the other figures must go up. We have, in terms of a decision of the Supreme Court in the human conditions in 362 prisons, set up what is called Under Trial Review Committee. This consists of the district and session judge, member secretary, the DLSA, the district magistrate, SP police, jail superintendent, and etc. So these are the cases, and we have identified 14 categories of cases of the under trials where bail should be applied and given. Now, if you look at those categories, one is 436A, then UTPs eligible under 436. Yesterday I was talking to some LADCS councils, they were not even aware of the provisor to 436, where a person has been, because these are 436 deals with bailable offences, but you have to submit a bond, so surety has to be given. So they are not able to give surety. The law says if he within 1 week he is not able to give surety, then release him on personal bond. He is supposed to be deemed to be an indigent person. Then we have provisions which have been dealt with in the form of 167(2), the default bail clause, statutory bail clause. But I have an issue over here. We'll have to upgrade our systems, because if the accused does not know about that clause, how will he get the benefit? He is dependent upon either the lawyer or the legal aid counsels. So we have to keep a check, and how do we ensure this? Whether we were prepared, if the lawyer, did he move the application for statutory bail or not within that time? We also yesterday had a word with regard to subsection 6 to 437, which deals with trials before magistrate and your right to bail in case the trial has not progressed for 60 days since the commencement. This is the Pan-India data with regard to the number of the meetings which have been held, number of cases in which applications have been moved. This is a little disturbing, because if you look at the number of recommendees, is fairly large, but the actual number released is much lower. So there is some disconnect. I was told when we visited the prison and got the information that some prisoners are not ready to come out because they are involved in multiple offences. But then we should have a column that why this application is not being filed or why they are not being released. In case our courts are not releasing, then it's a matter of concern. Then we have to file appeals or whatever recourse to legal remedies available. We have to also sensitize our judges. And once there is a judgment of the Supreme Court, that precedent has to be known to everybody, must be shown, you must be aware of that precedent, and you must thereupon ask the trial courts, district courts to apply that principle. This is the data with regard to the under trial review committees in Rajasthan. 680 were held in the year 2023. The 6,034 were recommended for release. 2,068 were released. So this requires a little elaboration and study. Why only 1/3 were released? Why all of them, or 50% or 60% were not released? This was a special campaign which we had done for the figure is somewhat identical. Now with regard to the legal literacy clubs, etc., this gives a fair background of data. we have to, this I have to leave to the legal clinics, etc. We in the PLVs, as far as PLVs is concerned, yes, the students are very important members of the PLVs, but there's one issue which is coming up with the students, is with regard to interpersonal ability. Because the section which is requiring legal aid are socially and economically backward. That interpersonal ability of the students to be able to connect with them requires help and assistance of the teachers and the lecturers. I came across cases where the person says they come for a survey once in a year and they go back. So why should I give him information? I think some students are here, some teachers are here, some lecturers will be here. You please take note of it. And the lawyers, advocates, please help them. Because you have interpersonal skills, you have with experience and wisdom and intellect developed it. Please help them. After all, if the legal profession is to do well, your assistance is required. And unless the younger generation is good, we'll be in a problem. This is one thing which we have established which is doing well, and I'm very happy about the new data box which has come up. I think that's an excellent idea. It's an excellent idea. We have been asking, I can understand many of the poor and marginalized may not have smartphones, but at least PLVs have the smartphones. So they can push it through. But what we have done is now we have a national helpline number. That national helpline number, we are developing the frequently asked questions and the answers. We'll be also sending them. I think within this month or April, you'll get the, and then we'll ask them for those. I'll also request the bar, the advocates, if they have any suggestions to give on frequently asked questions and the answers, because they are dealing with the people at very great level, do contribute, do help us. You'll be doing a good work. We'll appreciate it and we'll acknowledge it by writing a letter to you. These are the three other systems which we have in place. E-prison is taking baby steps. I went and we spoke about whether e-prison's platform was working in some places. They said there's some integrity issues, there were some issues. Legal aid case management system, there's a problem. We'll be discussing it in the second half. Updating of data is not taking place. But I'm afraid legal services management system, LSMS, has not worked. It clearly shows that there is a judicial divide. People do not have the ability to access our network, and that's quite, I think it's natural, because if a person is wanting legal aid, he's probably belonging to that section of the society which doesn't know how to use digital devices. So these are the figures with regard to the LSMS in Rajasthan in there. I've already spoken about the paralegal volunteers. The matter of concern is we have only 4 paralegal volunteers having expert in particular field in Rajasthan. Similarly, the in prison, normally prisoners are appointed as paralegal volunteers. They are given 3 days of training. Or everybody who's appointed as a paralegal volunteer is given 3 days of training. They are also paid 500 rupees a day, maximum of 7,000. There may be some calls for revision, we'll examine that. But they are supposed to work for 10 days and give us the data. So they are actually our eyes, ears, and mouthpiece, as well as hands. So we have to strengthen them. This requires an upgradation. These are the legal services clinics which we have. The good thing is we have 8 mobile vans in Rajasthan which can tour and go to different remote parts of the villages, because the villages are well spread out, and deal with the situation. Quality to access to justice. Now we have set up this legal aid defense counsel system. It has worked well. The data, initial data, is showing that the success rate has gone up. We are able to even have youngsters come in and do well. Wherever any suggestions are there, we'll be incorporating those. These are the benefits of the legal aid, LADCS as we call it. There are three aspects to LADCS. One is the physical infrastructure, one is capacity building, and human resource. Human resource is perhaps the most important. Here, one thing which I want help, and possibly we can take the help of advocates also, is the monitoring and the mentoring committee. In that, I feel instead of just leaving it to the judicial members of the legal aid committees, we must have one or two members of the bar, because they can tell you exactly what is happening. And perhaps the judge of the High Court also getting involved, who is not the administrative judge of that area. Because that can ensure you have to go through the judgments, you have to go through the cross-examination conducted, and you'll find. And mentoring means also, it's not only reprimanding or saying he's not doing well. Mentoring him is also how to guide him. And that's where your help is required. They can be complex cases sometimes, under the POSCO Act or under some other act. In fact, one disturbing thing which I have noticed as far as data with regard to under trial and the prisoners is concerned, is that almost 16.94% cases today of the inmates in jail, whether as under trials or convicts, is in property or economic offences, which is too high. Are we overindulging or criminalizing civil cases into criminal cases? Supreme Court of late has come very strictly. This should not happen. This destroys the rule of law. It's easy to argue and say, at least he's getting the money. He deserves. I'm sorry. He should go to the civil court, get the money. That's wrong. By any stretch of imagination cannot be justified. The other worrisome sign is attempt to murder cases is 11.27%. So be careful in that. The members of the judiciary are here, are those which are punishable as a lesser offense being converted into 307. Yes, POSCO Act has also shown an increase. 14.61% is substantially high. If we combine murder, property economic, POSCO, and attempt to murder and NDPS, it almost constitutes 80% of the under trials. NDPS, I'll leave aside, but there is something which has to be done, which has to be thought of. I gave those figures because you get a fair idea of what is going around in the society. As far as under trials in the jail are concerned, we have about, in yesterday's data is, as on 27/3, in fact, 16,769, that is almost 75% are on trials in jails of Rajasthan, and 25%, that is 5,681, are convicts. The total prison population is 22,450, or around that figure. This is the infrastructure we have. We do have chief LADCs in most of the districts, except in one. Deputy chief, there is some shortfall. Legal assistants are 50. I checked up on the average case pendency before by dividing the number with the total number of cases, which I could visualize, about 8,000 odd. It gives a pendency of about 44.45 cases per legal aid counsel, which is fine. I think it's fairly good. This gives the details of the total number of cases. I have some problem with this figure 8,000 which I mentioned. This includes also the remand work, bail work. In fact, we should confine it to sessions and magistrate court cases, really speaking, because these arise from that. Yes, we'll have to account for their visits to jail because they are interacting. Their work of LADCs is not only confined to court work, it also means going to the jail, interacting, building that confidence and helping out. So that has to be accounted for, but bifurcation has to be slightly modified. Now, I'll turn to the second part of what we have. We have 13 schemes under the NALSA with regard to what we can do. One of the schemes is with regard to victims. This gives the details of total number of beneficiaries under the different schemes. I'm not reading it out. You can have a look at it. These details are available. This gives the details of victim compensation which has been paid in Rajasthan. The figures are quite good and quite satisfied and happy with those figures. Witness protection in India virtually does not exist. I had the occasion to, in one case, in one of the holidays in summer vacations, ask my law clerks to deal with the 116 criminal cases which I had decided. And we came across the figures were that in almost 38% cases in Delhi, the prime witnesses had turned hostile. It's a very large sum. No study has been otherwise conducted, but it's a matter of concern. Now, I've given the reasons why they turned hostile. It's quite possible. There can be several reasons. It's not that when they turned hostile, they were not speaking the truth. It is possible they may not be aware. But there is also a possibility. And then we tried to visualize what are the consequences, what are the reasons, because we don't have that, we couldn't interact with them, but we tried to visualize what are the reasons. These are the provisions relating to the protection of child rights. We had, in spite of all that has been done, we realized that there was still a large number of prisoners who were juvenile on the date of the offense. So we started this campaign, Restoring the Youth, which was done recently. And you can see the figures. We were able to find some still. So it's a duty of you as a lawyer, as an advocate, as well as legal aid counsel, whenever you meet a young man whom you suspect may be a juvenile, take up their causes. Rehabilitation, reformation, this is where I think Rajasthan is number one. There is no doubt about it. As I pointed out, there are about 5,681 prisoners in convicts, and almost 1/3 are in open jails. There are 50 open jails. I do not think anywhere in the world this figure can be matched. 1/3 prisoners being in open jail. And the information I got, the data I got was people who come out of the open jail do not indulge in offenses. They are not repeat offenders. So we had seen, we can't imagine. I was so happy when I saw these figures. I think here I've asked them to give a write-up. We'll probably publish it in our bulletin. And this model can be made the role model for other states to follow. Premature release is an issue. In fact, my data shows, all India data shows only 5,035 prisoners were released prematurely. It's appalling. Something which has to be dealt with. Probation of Offenders Act, again, I feel is a little problem. We have to work on it. And you as lawyers and advocates also must ensure. Plea bargaining has not really picked up for various reasons. You may examine those reasons why it has not picked up. But Probation of Offenders Act is something which can be applied. This is the data with regard to premature release in Rajasthan. Now I come to mediation. We are proposing to have a new setup for mediation training. It will be a 40 hours thing because that's mandate of MCPC. 30 hours will be online with capsules of 1 hour each. You'll be able to log in and log out, and that will be captured. You'll have to pay maybe 100 rupees, 200 rupees, maybe 500 rupees, as we'll see how much is required, but different, maybe for seniors it may be less. And induction for 2.5 hours will be live or physical interactive. 2.5 hours in between will be again live or interactive. And 5 hours in the end will be live and interactive or physical. in which again questions will be asked. The benefit of this is, let me put it, we all believe mediation is very simple. We do it every day. It's the same thing as saying, my mother decides and adjudicates every day. Argumentative mind is very different from a mind of a conciliator. These are two separate things. Once you realize what formal mediation is, and it will change your life, the way you think it, because you do not become judgmental upon the conduct of others. What you do is, you try and reconcile. You try then bring them together. That's a far more difficult thing, but it's a future of litigation in India. I have some figures with regard to the ADR centers in mediation. Figures in Rajasthan require, I think it has to be promoted in a big way. 6,666 cases is very low. And 549 being decided by mediation is not acceptable. I think you people have to step in. And let me tell the bar and the men. I remember when this task of mediation was first rooted. I was just been elevated in 2005 as a judge, and the meeting was held in the law faculty, where we have all studied. Members of the bar were up in arms. We'll take away all our money. We'll ensure courts go on complete strike. We'll put the... Today, members of the bar, whenever we take out a scheme or a mediation, are the first. In fact, I had difficulty in selecting. The numbers were so huge. I'm talking of 2010, 8 and 10. Today the figures are, everybody wants to do mediation. And district courts earlier, to ensure credibility and acceptance of mediation as an institution, we had judges doing mediation. That number has gone down significantly. Advocates are doing mediation. And they're very happy doing it. In the High Court, the mediation center is completely manned and operated by advocates who have given up private practice, many of them, and are doing mediation. I'll just show you the success figures. This is the figure with regard to now 12A of the Commercial Courts Act, wherein pre-institution mediation is must, is mandatory. Figures are not very good, but there is a sign of hope, and I'll tell you where. If you look at 1920, these are financial year figures, these are not calendar year figures. The total number of successful mediations in pre-institutional mediations was 167. That's all in whole of India. Today, till December, the figure has gone to 7,431. Look at the jump. So it's catching on. Every year it's catching on. So don't miss out this opportunity. And remain as a lawyer, become a mediator. Otherwise, you'll be denying yourself your professional role in future. And that's true for the students also. Though we have a clause, you must have 10 years experience as a lawyer to be a mediator. That's something separate. But doing a course is something different. And getting interested in mediation is something different. As an alternative or as a co-profession with advocacy. These are the figures with regard to the Delhi High Court and the District Court mediation centers. The Delhi High Court Center, as I said, is completely mediators are only advocates. 47.6% cases settled, 16,000 odd cases settled, which is more than the number of pendency of original side cases in the Delhi High Court. We have pendency of about 10,000 cases. So that means the number of cases which have been settled are more than the entire pendency in the High Court. And the cases settled in the district court mediation centers is 250,000 plus. Is it not a matter of pride that we have been able to achieve those figures? and 68% cases have been settled. This, ultimately, we want PLVs to also come in. We'll be making a module of 10 hours for the PLVs for mediation, because we want to go have, community level mediation, which should become the norm before the case comes to court. It will help resolve a lot of differences, even crime will come down. Benefits of community mediation. Now last, I come to our Lok Adalats. I think this is a tremendous and a phenomenal success. I can't imagine if these number of cases were coming to the courts. It will lead to collapse. Now, this is the area where we require the bar's help also, the advocates' help and the judges' help, as to identify new areas where we can bring in Lok Adalats. Because 3 types of Lok Adalats: National Lok Adalat, Permanent Lok Adalat, E-Lok Adalats. E-Lok Adalats is gradually catching up. A lot of countries have E-Lok Adalat. You have a problem, say, with regard to purchase you have made. You go, you put in, this is the bill I purchased, this is the amount. The same email goes to the buyer, the seller. He has the option to say, I accept. Just like we do it when we buy it in e-platform. So he has the option to say, I accept, I'll give you so much money back. Or I don't accept. And this can be replicated even in cases of civil disputes. This is with regard to the disposal figures of Rajasthan. There's been a slight drop, but I think in January, but I think we'll catch up in the end. That's all. I think I've taken too much of your time, and thank you for your being so attentive and careful. In the end, I'd like to thank the Chief Justice and the judges of the Rajasthan High Court for their warm hospitality. It's been wonderful. Spending the 3 days over here, I gained a lot of knowledge and information, which I hope will help me. Thank you.
Thank you, Lordship. Your address was stupendous and remarkable. Lordship, with the aid of data, the way you explained the concept of legal aid and its challenges is breathtaking. It sums up the entire legal state status in the country, and it paves the way for action. I am sure the distinguished audience has taken the message in the complete earnest as conveyed by you. Lordship, we at RSLSA assure you that we will not leave any stone unturned in fulfilling the objectives of the legal as enshrined in the Constitution of India and as deliberated by you. Moving ahead, it is our esteemed honor and pleasure to present memento to our honorable guest from the Supreme Court of India. To do the honors, may I request Honorable Mr. Justice Manindra Mohan Srivastava, the Chief Justice of Rajasthan High Court, to present a memento to Honorable Mr. Justice Sanjeev Khanna, Judge Supreme Court of India and Executive Chairman, NALSA. Thank you, sir. I call upon Mr. Justice Pankaj Bhandari, Judge, Rajasthan High Court, to present a memento to Honorable Justice Mr. Sandeep Mehta, Judge, Supreme Court of India. Thank you very much, sir. Mr. Justice Dr. Pushpendra Singh Bhati, Judge, Rajasthan High Court and Chairman, RSLSA Jaipur, is known for his fine sense of judgment. Lordship is a man of words. May I request Lordship to give the vote of thanks.
My Lord, respected Honorable Justice Sanjeev Khanna Sahab, Judge, Supreme Court of India, and Executive Chairman of National Legal Service Authority. My Lords, respected Honorable Mr. Justice Sandeep Mehta, Judge, Supreme Court of India. My Lords, what happened, me and some of my brothers, including Justice Dinesh Mehta, we went to National Judicial Academy. So there was a gracious brother judge, and he shook his hand while saying thank you. So I couldn't understand why he is saying thank you. Then I understood that the judge, brother judge from the Meghalaya his name was Thank You in fact. So today my captain, my Chief Justice, has made me a thank you judge for this gracious occasion. I am extremely grateful for allowing me to be grateful to all those who have contributed to this wonderful function. It is a matter of great pride, deep gratitude, high energy that has been created by our captain, Honorable Justice Maninder Mohan Shrivastava Sahab, Chief Justice of Rajasthan, Patron-in-Chief, Rajasthan State Legal Service Authority, who, along with the strong team led by Honorable Justice Pankaj Bhandari Sahab, Judge Rajasthan High Court and Executive Chairman RSLSA, and our Secretary RSLSA, Mr. Mathur, our Registrar General, and all have been contributing a lot for last couple of days under the direct guidance of the brothers and sisters of this High Court. I'm particularly grateful to all the brothers and sisters who in this Platinum Jubilee year of Rajasthan High Court have helped this great institution to be ushered in a new era of enthusiasm, strength, progress, and futuristic wisdom. I express, when I wanted to make my thank you speech, I thought that this will be on behalf of only the Rajasthan High Court, but I realized during the journey being undertaken with the gracious luminaries that this is a thank you which has to be communicated on behalf of more than 100 crore citizens who are entitled for the benefits of the law of legal aid. Being thankful on their behalf does not mean, in fact, we are counter grateful to them also for allowing us to serve them in the shape of legal service authorities. It is a matter of great pride that today we are here. And when I said this thank you to the Executive Chairman of National Law Legal Service Authority, I first thought that it will be a singular thank you. But then I realized the magnitude. We have 50,000 lawyers to thank. We have 50,000 paralegal volunteers to thank. We have thousands and thousands of other people who have contributed to this great service of Legal Service Authority wherever it has been able to reach today and wherever it is likely to reach tomorrow. My lords, the District Legal Service Authority, Rajasthan being the bigger state than 126 countries in the world, have traveled hundreds and hundreds of kilometers from one corner to another corner to come here and be benefited by your lordship's kind presence and your guidance which you have bestowed upon us today. It is a matter of great pride that Rajasthan High Court, as per the journey depicted by the chairman, is doing a good job, although a lot remains to be done as per the statistics and as per the information which is available today and was made available to each one of us. We are extremely thankful, my lords, that you told us the value of the pious goal of Article 39A and Section 12 of the Legal Service Authority Act, which you have depicted so beautifully and so claritically before us. I am extremely also grateful, your lordships. Your lordships had first visited Rajasthan in 1971 war, when his father was in the process of establishing the income tax tribunal in Rajasthan. And since then, he has been in constant touch of Rajasthan. And your lordship's recent lines in one of his orders shows his deep love, affection, and knowledge about Rajasthan. And when I talk of this, I'll read those 5 lines for you. This is about the Chittorgarh, where your lordships have observed in their order that the Chittorgarh fort represents the quintessence of the tribute to nationalism, courage, medieval chivalry, sacrifice exhibited between the 7th and 16th centuries by several rulers. Like the Mewar, the rulers, the women, the children, the Chittorgarh fort has weathered and withstood many battles and has been a witness to the power and pride of the kings who occupied the fort. The history is replete with brave, extraordinary, indomitable courage exhibited by the occupants of the fort. I may also Though our Justice Farzan Ali is from Chittorgarh, and he would be also his chest would be swelling with pride when we talk of Chittor and we talk of the rulers of Mewad. But I'm sure every citizen of Rajasthan and this great nation is indebted to their courage and valor for the sake of the nation at large. Your Lordship's keen observation that there is a difference between the people who are entitled and the people who are actually able to reach out. That keen difference has to be taken note of and has to be worked upon. That seems to be the theme of what Your Lordship's message was to the team of Legal Service Authority. Lordship's better half, Madam, gracious Madam, Honorable Madam, Asha Khanna ma'am is also, we are thankful to you that you have spared all your time, ma'am, by coming all the way. And also, Lordships would have felt more at home because of you in Rajasthan for last 2 days, maybe visiting prisoners and jails and opal jails, and would have slightly, I mean, though it was a duty, but as which my lords have carried out, and also patted our backs in Rajasthan for our special endeavors like open air jail. It is an extremely encouraging position, which I am sure that we all will look up to increase in terms of the guidance which has been laid down. When I speak of Honorable Justice Sandeep Mehta, we in Rajasthan, all of us know him as an elder brother and a mentor. And today, while adorning the great seat of the Honorable Apex Court, my lords have again created what he was known for. He has dotted the judicial map with activism for the larger benefit of the society at large. I'll just give one example of hundreds, thousands of cases that your lordships have triggered and stimulated. That example is that your lordships deep imprint on every Balika Greh, every Nari Niketan, every juvenile home, every children's home has today a different reflection altogether only because your lordship's deep understanding. All these special places today carry the chart of meditation. They have open air gyms, they have smart TVs for education, and they have been continuously monitored by my lords for a huge duration. And today when we go to those places which belong to those special people whom we want to care, we find that an extraordinary care is in place, the care apparatus in place because of the personal attention that your lordship paid to those special places. My Lord the Chief Justice, one day I asked my Lord the Chief Justice, because he himself is he has great knowledge about legal service authority. So I asked him, sir, why is it not fair that these revenue courts are also being taken in the purview of the Lok Adalat, and these are not even judicial courts. At that time, I did not know. This was only a few days back. My Lord the Chief Justice told me that, Pushpendra, the definition of court in the Act includes the revenue court. And revenue court is the grassroots institution. And by including the revenue court, which is meant to be, as per the legislative intention, it is meant to be there, by including them in Lok Adalat, we are directly giving a special space and a special strength to the common man of this the great state. I'm thankful to his captaincy. As always, he has taken us ahead. Justice Bhandari is, my brother, is doing a great job as the chairman of the State Legal Service. And I'm sure his motivation to all of us, when I say I include not only my brothers and sisters from the High Court, but also from the DLSA secretaries and chairpersons who are here from all over the state. Symbolically, we have, from every walk of fraternity, we have people. I'm seeing that the leadership of the bar is also present here in sizable number. That is the presidents and the team members of Jaipur Bar, Jaipur High Court Association, and the Jaipur District Association, and the Rajasthan and the Jodhpur Rajasthan High Court Advocates Association president and members are also here. I see senior members of Bar Council also here. In the second row, I see that almost who's who and stalwarts of who are the senior advocates of this great institution of Rajasthan High Court are present here in large numbers, and I see a special sparkle in their eyes while they see the journey of Rajasthan and Legal Service Authority, which is not only a compliment, but I say it is a special commendation, because they being the seniors, if they commend us, it becomes more encouraging and gives us more strength to function on such occasions. I'm extremely grateful and thankful to all the wonderful ladies and gentlemen to have spared their valuable time for 110 crores of persons for whose entitlement and reach out we are all committed to work, we are committed to go ahead, and we are committed to take them to the logical place as guided by the luminaries in the session. I am also thankful to the students, the media. The media is important because ultimately to reach out to 110 crores, these positive developments which have happened on the platform of Legal State Service Authority ought to be highlighted and ought to be given, because unless there is an awareness, as in one of the lectures Justice Khanna observed, that people still ask the legal aid lawyers कि आपको अभी और कितना पैसा देना है, आपकी फीस कितनी होगी, probably not being aware that legal service is taking care of those things. So that is the place where we have to create the difference, and I assure you, my lords, that under your able leadership and under the able leadership of Justice Mehta and our Chief Justice and Justice Bhandari and everybody who's sitting here, I'm sure we will be able to achieve the goal, because this is going to perlocate to the last citizen of India for whom this law, the deep ethos has been ingrained, and we all are part of this journey. We are extremely thankful to each one of you present here. Thank you, everyone. Thank you for making me there. Thank you, Judge, for one day. Thank you.
Thank you, Lordship, for such a wonderful vote of thanks that not only mentions the presence and time devoted by the dignitaries and the august audience here, it also reaches to all those who are serving the law in the state. Lastly, Lordship, your wit is always the best. With this, we come to an end of the first session. May I now request all to rise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Thank you very much.